Please be seated. The sitting is open. The court meets today pursuant to Article 58 of its statute and Article 94 of its rules to read its judgment in the case concerning the Arbitral Award of 3 October 1899, Guyana versus Venezuela. In view of the current COVID-19 pandemic, the court has opted for a hybrid sitting. 4 judges are present with me here in the Great Hall of Justice, namely Judges Tomka, Abraham, Gevorgian, and Iwasawa, while Vice President Shue, Judges Benuna, Donahue, Gaya, Sebutinde, Bandari, Robinson, Salam, and Judge Ad hoc Charlesworth are participating in the sitting remotely. For reasons made known to me, Judges Cansado, Trinidad, and Crawford, who duly participated in the deliberation and the final vote in this case, are unable to sit with us today. Before we start the reading of the judgment, I would like to pay solemn tribute on behalf of the court to the memory of one of its former members, Judge Abdallah Fikri El-Khani, who passed away on 7 December 2020. Born in Damascus, Syria on 24 January 1925, Judge El-Khani graduated from the Université Saint-Joseph in Beirut and the Syrian University in Damascus, where he obtained an LLM in 1947. The same year, he was admitted to the Syrian bar. After practicing law for a few years, he was appointed lecturer in law at the University of Damascus in 1954. In parallel, he began his distinguished career in public service, assuming various positions within the Syrian government and diplomatic service. In particular, he was appointed Minister Plenipotentiary from 1959 to 1969, Permanent Representative to UNESCO from 1966 to 1969, Head of the Syrian delegation to the United Nations General Assembly and Security Council in 1970, Minister for Foreign Affairs ad interim from 1973 to 1974, and Ambassador to India from 1978 to 1981. From January 1981, he was elected to the court to succeed his fellow countryman, Mr. Salah al-Din Tarazi, as judge. Judge El-Khani performed his functions as a member of the court with integrity and dedication until the end of his mandate in February 1985. He continued to sit in the case concerning the continental shelf, Libyan Arab Jamahiriya versus Malta, until its completion. After leaving the court, he presided over numerous arbitral tribunals. In the 1990s, he was one of 3 foreign judges of the newly established Constitutional Court of Bosnia and Herzegovina. As president of the court, and on behalf of the members of the court, the registrar, and all the registry staff, I would like to extend our sincere condolences to the Syrian people and government, and to the family and friends of Judge El-Khani at this difficult time. I invite you to observe a minute of silence in memory of Judge El-Khani. I thank you. I will now read out the judgment in the present case. I would recall that the proceedings in this case were instituted on 29 March 2018 by the Cooperative Republic of Guyana against the Bolivarian Republic of Venezuela with regard to a dispute concerning, and I quote, the legal validity and binding effect of the award regarding the boundary between the colony of British Guyana and the United States of Venezuela of 3 October 1899, end of quote. In its application, Guyana sought to found the jurisdiction of the court under Article 36, Paragraph 1 of the Statute of the Court on Article 4, Paragraph 2 of the Agreement to resolve the controversy between Venezuela and the United Kingdom of Great Britain and Northern Ireland over the frontier between Venezuela and British Guyana, signed at Geneva on 17 February 1966, to which I will refer as the Geneva Agreement. Guyana explains that, pursuant to Article 4, Paragraph 2 of the Geneva Agreement, Guyana and Venezuela, and I quote, mutually confer upon the Secretary General of the United Nations the authority to choose the means of settlement of the controversy, and on 30 January 2018, the Secretary General exercised his authority by choosing judicial settlement by the court, end of quote. I would also recall that on 18 June 2018, Venezuela indicated that it considered that the court lacked jurisdiction to hear the case and announced that it would not participate in the proceedings. The court therefore decided that in the circumstances of the case, it was necessary, first of all, to resolve the question of its jurisdiction, and that this question should accordingly be separately determined before any proceedings on the merits. The court now renders its judgment on the question of its jurisdiction. In accordance with the usual practice, I will not read out the introductory paragraphs of the judgment, which set out the main elements in the procedural history of the case. I will also omit some paragraphs and summarize others. I will therefore begin reading the judgment at paragraph 24. The full text of the judgment will, of course, be available at the close of the sitting. The court wishes, first of all, to express its regret at the decision taken by Venezuela not to participate in the proceedings before it. The non-appearance of a party obviously has a negative impact on the sound administration of justice. In particular, the non-appearing party forfeits the opportunity to submit evidence and arguments in support of its own case and to counter the allegations of its opponent. For this reason, the court does not have the assistance it might have derived from this information, yet it must nevertheless proceed and make any necessary findings in the case. The court emphasizes that the non-participation of a party in the proceedings at any stage of the case cannot, in any circumstances, affect the validity of its judgment. A judgment on jurisdiction, as on the merits, is final and binding on the parties under Articles 59 and 60 of the statute. Should the examination of the present case extend beyond the current phase, Venezuela, which remains a party to the proceedings, will be able, if it so wishes, to appear before the court to present its arguments. Though formally absent from the proceedings, non-appearing parties sometimes submit to the court letters and documents in ways and means not contemplated by the rules of court. It's valuable for the court to know the views of both parties in whatever form those views may have been expressed. The court will therefore take account of Venezuela's memorandum to the extent that it finds it appropriate in discharging its duty under Article 53 of the statute to satisfy itself as to its jurisdiction to entertain the application. The Court turns first to the historical and factual background of the case. It recalls that at the time the present dispute arose, Guyana was still a British colony known as British Guyana. It gained independence from the United Kingdom on 26 May 1966. In the 19th century, the United Kingdom and Venezuela both claimed the territory comprising the area between the mouth of the Essequibo River in the east and the Orinoco River in the west. In the 1890s, the United States of America encouraged both parties to submit their territorial claims to binding arbitration. The exchanges between the United Kingdom and Venezuela eventually led to the signing in Washington of a treaty of arbitration on 2 February 1897, to which I will refer as the Washington Treaty. The Arbitral Tribunal established under the Washington Treaty rendered its award on 3 October 1899. The following year, a joint Anglo-Venezuelan commission was charged with demarcating the boundary established by the 1899 award. On 10 January 1905, after the boundary had been demarcated, the British and Venezuelan commissioners produced an official boundary map and signed an agreement accepting inter alia that the coordinates of the points listed were correct. In 1962, Venezuela informed the Secretary General and the Fourth Committee of the UN General Assembly that it considered there to be a dispute between itself and the United Kingdom concerning the frontier between Venezuela and British Guyana, and it claimed that the 1899 award was null and void. The United Kingdom, for its part, rejected this contention. In the early 60s, efforts were made by the parties to resolve the dispute, which finally led to the signing of the Geneva Agreement on 17 February 1966. On 26 May 1966, Guyana, having attained independence, became a party to the Geneva Agreement alongside the governments of the United Kingdom and Venezuela. The Geneva Agreement provides, first, for the establishment of a mixed commission to seek a settlement of the controversy between the parties. In addition, Article 4, Paragraph 1 states that should this commission fail in its task, the governments of Guyana and Venezuela shall choose one of the means of peaceful settlement provided for in Article 33 of the United Nations Charter. Article 4, Paragraph 2 also provides that should those governments fail to reach agreement, the decision as to the means of settlement shall be made by an appropriate international organ upon which they both agree, or failing that, by the Secretary General of the United Nations. The Mixed Commission was established in 1966. It reached the end of its mandate in 1970 without having arrived at a solution. It thus fell to Venezuela and Guyana, under Article 4 of the Geneva Agreement, to choose one of the means of peaceful settlement provided for in Article 33 of the United Nations Charter. However, in view of the disagreements between the parties, a moratorium on the dispute settlement process was adopted, which lasted 12 years. The application of Article 4 of the Geneva Agreement was resumed from 18 June 1982. The parties failed again to reach an agreement on the choice of one of the means of peaceful settlement provided for in Article 33 of the Charter. They also failed to agree on the choice of an appropriate international organ to decide on the means of settlement as provided for in Article 4, Paragraph 2 of the Geneva Agreement. The parties therefore proceeded to the next step and referred the decision on the means of settlement to the Secretary General of the United Nations. The Secretary General agreed by a letter of 31 March 1983 to undertake the responsibility conferred upon him under Article 4, Paragraph 2 of the Geneva Agreement. After years of meetings and discussions, in early 1990, the Secretary General chose the good offices process as the appropriate means of settlement. Between 1990 and 2014, the good offices process was led by 3 personal representatives appointed by successive Secretaries General. In September 2015, the Secretary General, Mr. Ban Ki-moon, held a meeting with the heads of state of Guyana and Venezuela. Thereafter, on 12 November 2015, the Secretary General issued a document entitled The Way Forward, in which he informed the parties that if a practical solution to the controversy were not found before the end of his tenure, he intended to initiate the process to obtain a final and binding decision from the International Court of Justice. In his statement of 16 December 2016, the Secretary General said that he had decided to continue with the good offices process for a further year with a new personal representative with a strengthened mandate of mediation. He also announced that, and I quote, if by the end of 2017, the Secretary General concludes that significant progress has not been made toward arriving at a full agreement for the solution of the controversy, he will choose the International Court of Justice as the next means of settlement unless both parties jointly request that he refrain from doing so. End of quote. After taking office on 1 January 2017, the new Secretary General, Mr. Antonio Guterres, continued with the good offices process for a final year in conformity with his predecessor's decision. In letters dated 30 January 2018 to both parties, the Secretary General stated that he had carefully analyzed the developments in the good offices process during the course of 2017 and announced it, and I quote, consequently, I have fulfilled the responsibility that has fallen to me within the framework set by my predecessor, and significant progress not having been made toward arriving at a full agreement for the solution of the controversy, have chosen the International Court of Justice as the means that's now to be used for its solution. End of quote. On 29 March 2018, Guyana filed its application in the registry of the court. The court now turns to the interpretation of the Geneva Agreement and examines first the use of the term controversy. It concludes that the controversy that the parties agreed to settle through the mechanism established under the Geneva Agreement concerns the question of the validity of the 1899 award, as well as its legal implications for the boundary line between Guyana and Venezuela. In this context, the court takes up the question of whether the parties gave their consent to the judicial settlement of the controversy under Article 4, Paragraph 2 of the Geneva Agreement, and whether the parties conferred on the Secretary General the authority to choose by a decision which is binding on them the means of settlement of this controversy. The first sentence of Article 4, Paragraph 2 of the Geneva Agreement provides that the parties shall refer the decision to the Secretary General. These terms, taken together, indicate that the parties made a legal commitment to comply with the decision of the third party on whom they conferred such authority, in this instance, the Secretary General of the United Nations. As regards the object and purpose of the Geneva Agreement, the Court notes that the purpose of a treaty may be indicated in its title and preamble. In the present case, the agreement is entitled Agreement to Resolve the Controversy over the Frontier between Venezuela and British Guyana, and its preamble states that it was concluded to resolve that controversy. The agreement also refers in Article 1 to the task of seeking satisfactory solutions for the practical settlement of the controversy. This indicates that the object and purpose of the Geneva Agreement is to ensure a definitive resolution of the controversy between the parties. In view of the foregoing, the Court considers that the parties conferred on the Secretary General the authority to choose, by a decision which is binding on them, the means to be used for the settlement of their controversy. The Court then turns to the interpretation of the last sentence of Article 4, Paragraph 2 of the Geneva Agreement, which provides that the Secretary General, and I quote, shall choose another of the means stipulated in Article 33 of the Charter of the United Nations, and so on, until the controversy has been resolved, or until all the means of peaceful settlement there contemplated have been exhausted. End of quote. Given that Article 4, Paragraph 2 of the Geneva Agreement refers to Article 33 of the Charter of the United Nations, which includes judicial settlement as a means of dispute resolution, the Court considers that the parties accepted the possibility of the controversy being settled by that means. The Court notes that according to the wording of Article 4, Paragraph 2 of the Geneva Agreement, the parties conferred on the Secretary General the authority to choose among the means of dispute settlement provided for in Article 33 of the Charter until the controversy has been resolved. It observes that Article 33 of the Charter includes, on the one hand, political and diplomatic means, and on the other, adjudicatory means such as arbitration or judicial settlement. The willingness of the parties to resolve their controversy definitively is indicated by the fact that the means listed include arbitration and judicial settlement, which are by nature binding. The phrase "and so on until the controversy has been resolved" also suggests that the parties conferred on the Secretary General the authority to choose the most appropriate means for a definitive resolution of the controversy. The Court considers that the Secretary General's choice of a means that leads to the resolution of the controversy fulfills his responsibility under Article 4, Paragraph 2 of the Geneva Agreement in accordance with the object and purpose of that instrument. The Court concludes that the means of dispute settlement at the disposal of the Secretary General, to which the parties consented under Article 4, Paragraph 2 of the Geneva Agreement, include judicial settlement. The Court notes that its conclusion is not called into question by the phrase "or until all the means of peaceful settlement there contemplated have been exhausted" at paragraph 2 of Article 4, which might suggest that the parties had contemplated the possibility that the choice by the Secretary General of the means provided for in Article 33 of the Charter, which include judicial settlement, would not lead to a resolution of the controversy. There are various reasons why a judicial decision, which has, of course, the force of res judicata and clarifies the rights and obligations of the parties, might not in fact lead to the final settlement of a dispute. It suffices for the court to observe that in this case, a judicial decision declaring the 1899 award to be null and void without delimiting the boundary between the parties might not lead to the definitive resolution of the controversy. The court therefore concludes that the parties consented to the judicial settlement of their controversy. The court then turns to the examination of whether the parties' consent to the means of judicial settlement, as expressed in Article 4, Paragraph 2 of the Geneva Agreement, is subject to certain conditions. In this context, the court takes up the question whether that consent is subject to the condition that the Secretary General follow the order in which the means of settlement are listed in Article 33 of the United Nations Charter. The court observes that the use of the verb choose in Article 4, Paragraph 2 of the Geneva Agreement excludes the idea that it is necessary to follow the order in which the means of settlement appear in Article 33 of the Charter. In the view of the court, the parties understood the reference to a choice of the means, and should the first means fail, of another of those means, as signifying that any of those means could be chosen. The expression "and so on" refers to a series of actions or events occurring in the same manner and merely conveys the idea of decision-making continuing until the controversy is resolved or all the means of settlement are exhausted. Therefore, the ordinary meaning of this provision indicates that the Secretary General is called upon to choose any of the means listed in Article 33 of the Charter, but is not required to follow a particular order in doing so. In the view of the Court, an interpretation of Article 4, Paragraph 2 of the Geneva Agreement, whereby the means of settlement should be applied successively in the order in which they are listed in Article 33 of the Charter, could prove contradictory to the object and purpose of the Geneva Agreement for a number of reasons. First, the exhaustion of some means would render recourse to other means pointless. Second, such an interpretation would delay resolution of the controversy, since some means may be more effective than others in light of the circumstances surrounding the controversy between the parties. In contrast, the flexibility and latitude afforded to the Secretary General in the exercise of the decision-making authority conferred on him contribute to the aim of finding a practical, effective, and definitive resolution of the controversy. Thirdly, nothing in Article 4, Paragraph 2 of the Geneva Agreement requires the Secretary General to consult with the parties before choosing a means of settlement. The Court observes that although successive Secretaries General consulted with the parties, it's clear from the various communications of the Secretaries General that the sole aim of such consultation was to gather information from the parties in order to choose the most appropriate means of settlement. The Court thus concludes that having failed to reach an agreement, the parties entrusted to the Secretary General, pursuant to Article 4, Paragraph 2 of the Geneva Agreement, the role of choosing any of the means of settlement set out in Article 33 of the Charter. In choosing the means of settlement, the Secretary General was not required to follow a particular order or to consult the parties on that choice. Finally, the parties also agreed to give effect to the decision of the Secretary General. The Court next examines whether, by choosing the International Court of Justice as the means of judicial settlement for the controversy between Guyana and Venezuela, the Secretary General acted in accordance with Article 4, Paragraph 2 of the Geneva Agreement. The Court notes that in taking his decision of 30 January 2018, the Secretary General expressly relied upon Article 4, Paragraph 2 of the Geneva Agreement. The Court is of the view that the good offices process previously chosen by the Secretary General did not lead to a solution of the controversy within the terms of Article 4, Paragraph 2, and that this provision thus called upon him to choose another means of settlement. Neither Article 4, Paragraph 2 of the Geneva Agreement nor Article 33 of the Charter of the United Nations expressly mentions the International Court of Justice. However, the Court, being the principal judicial organ of the United Nations, constitutes a means of judicial settlement within the meaning of Article 33 of the Charter. The Secretary General could therefore choose the Court on the basis of Article 4, Paragraph 2 of the Geneva Agreement as the judicial means of settlement of the controversy between the parties. Moreover, the circumstances surrounding the conclusion of the Geneva Agreement indicate that recourse to the International Court of Justice was contemplated by the parties during their negotiations. In particular, the Court gives weight to a statement made by the Minister for Foreign Affairs of Venezuela before the Venezuelan National Congress on the occasion of the ratification of the agreement. In light of the aforementioned, the Court is of the view that by concluding the Geneva Agreement, both parties accepted the possibility that under Article 4, Paragraph 2 of that instrument, the Secretary General could choose judicial settlement by the International Court of Justice as one of the means listed in Article 33 of the Charter of the United Nations for the resolution of the controversy. The decision of the Secretary General of 30 January 2018 was therefore taken in conformity with the terms of Article 4, Paragraph 2 of the Geneva Agreement. The Court now turns to the legal effect of the decision of the Secretary General on its jurisdiction under Article 36, Paragraph 1 of its statute. It recalls that its jurisdiction is based on the consent of the parties and is confined to the extent accepted by them. Both this Court and its predecessor have previously observed in a number of cases that the parties are not bound to express their consent to the Court's jurisdiction in any particular form. Consequently, there is nothing in the Court's statute to prevent the parties from expressing their consent through the mechanism established under Article 4, Paragraph 2 of the Geneva Agreement. The Court must, however, satisfy itself that there is an unequivocal indication of the desire of the parties to a dispute to accept the jurisdiction of the Court in a voluntary and indisputable manner. The Court recalls that Venezuela has argued that the Geneva Agreement is not sufficient in itself to found the jurisdiction of the Court and that the subsequent consent of the parties is required even after the decision of the Secretary General to choose the International Court of Justice as the means of judicial settlement. However, the decision taken by the Secretary General, in accordance with the authority conferred upon him under Article 4, Paragraph 2 of the Geneva Agreement, would not be effective if it were subject to the further consent of the parties for its implementation. Moreover, an interpretation of Article 4, Paragraph 2, that would subject the implementation of the decision of the Secretary General to further consent by the parties would be contrary to this provision and to the object and purpose of the Geneva Agreement, which is to ensure definitive resolution of the controversy, since it would give either party the power to delay indefinitely the resolution of the controversy by withholding such consent. For all these reasons, the Court concludes that by conferring on the Secretary General the authority to choose the appropriate means of settlement of their controversy, including the possibility of recourse to judicial settlement by the Court, Guyana and Venezuela consented to its jurisdiction. The text, the object and purpose of the Geneva Agreement, as well as the circumstances surrounding its conclusion, support this finding. It follows that the consent of the parties to the jurisdiction of the Court is established in the circumstances of this case. With regard to the seizing of the Court by Guyana, the Court is of the view that an agreement of the parties to seize the Court jointly would only be necessary if they had not already consented to its jurisdiction. However, having concluded above that the consent of the parties to the jurisdiction of the Court is established in the circumstances of this case, either party could institute proceedings by way of a unilateral application under Article 40 of the Statute of the Court. The Court, therefore, is of the view that it has been validly seized of the dispute between the parties by way of the application of Guyana. The Court finally examines whether all the claims advanced by Guyana fall within the scope of the Court's jurisdiction. In this context, the Court first ascertains whether Guyana's claims in relation to the validity of the 1899 award about the frontier between British Guyana and Venezuela fall within the subject matter of the controversy that the parties agreed to settle through the mechanism set out in Articles 1 to 4 of the Geneva Agreement. The Court recalls that Article 1 of the Geneva Agreement refers to the controversy that has arisen between the parties to the Geneva Agreement as a result of Venezuela's contention that the 1899 award about the frontier between British Guyana and Venezuela is null and void. As stated earlier, the subject matter of the controversy which the parties agreed to settle under the Geneva Agreement relates to the validity of the 1899 award and its implications for the land boundary between Guyana and Venezuela. The opposing views held by the parties to the Geneva Agreement on the validity of the 1899 award is demonstrated by the use of the words Venezuelan contention in Article 1 of the Geneva Agreement. The Court considers that the use of the word contention points to the opposing views between the parties to the Geneva Agreement regarding the validity of the 1899 award. This interpretation is consistent with the object and purpose of the Geneva Agreement, which was to ensure a definitive resolution of the dispute between Venezuela and the United Kingdom over the frontier between Venezuela and British Guyana, as indicated by its title and preamble. Indeed, it would not be possible to resolve definitively the boundary dispute between the parties without first deciding on the validity of the 1899 award about the frontier between British Guyana and Venezuela. The court, therefore, concludes that Guyana's claims concerning the validity of the 1899 award about the frontier between British Guyana and Venezuela and the related question of the definitive settlement of the land boundary dispute between Guyana and Venezuela fall within the subject matter of the controversy that the parties agreed to settle through the mechanism set out in Articles 1 to 4 of the Geneva Agreement, in particular, Article 4, Paragraph 2 thereof, and that as a consequence, the Court has jurisdiction, ratione materiae, to entertain these claims. With respect to the Court's jurisdiction, ratione temporis, the Court notes that the scope of the dispute that the parties agreed to settle through the mechanism set out in Articles 1 to 4 of the Geneva Agreement is circumscribed by Article 1 thereof, which refers, and I quote, to the controversy which has arisen as a result of the Venezuelan contention that the Arbitral Award of 1899 is null and void, end of quote. The Court's jurisdiction is therefore limited, ratione tempore, to the claims of either party that existed on the date the Geneva Agreement was signed, on 17 February 1966. Consequently, Guyana's claims arising from events that occurred after the signature of the Geneva Agreement do not fall within the scope of the jurisdiction of the Court, ratione tempore. In light of the foregoing, the Court concludes that it has jurisdiction to entertain Guyana's claims concerning the validity of the 1899 award about the frontier between British Guyana and Venezuela and the related question of the definitive settlement of the land boundary dispute between the territories of the parties. I will now read out the operative part of the judgment. For these reasons, the Court, 1, by 12 votes to 4, finds that it has jurisdiction to entertain the application filed by the Cooperative Republic of Guyana on 29 March 2018, insofar as it concerns the validity of the Arbitral Award of 3 October 1899 and the related question of the definitive settlement of the land boundary dispute between the Cooperative Republic of Guyana and the Bolivarian Republic of Venezuela. In favor, President Yusuf, Vice President Shue, Judges Tomka, Cansado, Trinidade, Donahue, Sebutinde, Bandari, Robinson, Crawford, Salam, Iwasawa, Judge ad hoc Charlesworth. Against, Judges Abraham, Benuna, Gaia, Gevorgia. 2, unanimously finds that it does not have jurisdiction to entertain the claims of the Cooperative Republic of Guyana arising from events that occurred after the signature of the Geneva Agreement. I shall now call upon the Registrar to read the operative part of the judgment in French.
Merci, Monsieur le Président. Par ces motifs, la Cour, 1, par 12 voix contre 4, dit qu'elle a compétence pour connaître de la requête déposée par la République coopérative du Guyana le 29 mars 2018, dans la mesure où elle se rapporte à la validité de la sentence arbitrale du 3 octobre 1899 et à la question connexe du règlement définitif du différend concernant la frontière terrestre en la République coopérative du Guyana et la République bolivarienne du Venezuela. Pour M. Youssouf, président, Mme Choué, vice-présidente, Messieurs Tomka Cansado Trindade, Mesdames Donoyou Sebutinde, Messieurs Bandari Robinson, Crawford, Salam, Iwasawa, juge, Madame Charlesworth, juge ad hoc. Contre, Messieurs Abraham, Benouna, Gaïa, Gevorgian, juge. 2. À l'unanimité, dit qu'elle n'a pas compétence pour connaître des demandes de la République coopérative du Guyana qui sont fondées sur des faits survenus après la signature de l'accord de Genève.
I thank the registrar. Judge Tomka appends a declaration to the judgment of the court. Judges Abraham and Benuna append dissenting opinions to the judgment of the court. Judges Gaia and Robinson append declarations to the judgment of the court. Judge Gevorgian appends a dissenting opinion to the judgment of the court. The text of the judgment is available from today in TypeScript. It will also be available shortly on the court's website. The printed text will be available in the near future. As the court has no other business before it today, I declare the sitting closed.